All right. Hello, everybody. And today we are in constitutional law again. And we are going to be covering judicial powers, actors, sovereignty, and state action. So today's class, you guys, is about everything that has to happen before a court ever decides whether someone's rights were violated. Most students come into constitutional law expecting to argue about rights immediately, right? You see speech or race or privacy, guns, religion, right? We all know, right, that these are constitutional issues. And our instinct is to ask, was this unconstitutional? Right? And we just want to jump into it. But remember, that's not where the courts are going to start. And so that's not where we start. Before a court ever decides whether a right was violated, it has to decide whether it's allowed to decide anything at all, right? And that requires moving through a series of structural and jurisdictional gates, right? These are threshold questions. And courts move through these series of gates, right? Step by step. And if a case cannot pass through one gate, then the analysis stops. And so our goal today is to understand those gates, not just to memorize them, but to understand why courts insist on them. And so in our first session, we went through judicial review, right? Does the court have the authority to hear and decide on this case, right? Do we have does the court have the ability to redress this injury, right? And then we barely touched on in the last one identifying the actor, right? And state action. But we've also got to talk about sovereign immunity, right? And so as we go through, we're going to start going through and really looking into these threshold questions. Now, constitutional analysis follows a top down order, right? It is very, very top down, similar to contracts, right? And this order of operations is not optional, right? We don't, just like in contracts, we cannot start talking about the breach and the remedies until we determine what the governing law is and whether a contract was formed. Constitutional law is the same thing, right? It's the same thing. Before we can get into, did you violate somebody's constitutional right to privacy or right to speech? We have to start at the top. And we have to start with what? We have to start with judicial review, justicability, right? Case and controversy requirements. Then we get into who is the state actor, who can be sued, right? And so think of this as like a hallway with locked doors, right? You can't open door you do not open door 4 if door 2 is locked. So the steps are, can a court decide the case, right? Who's acting? Who can be sued and for what relief? Is there state action? And then only then do we ask about those powers or rights, right? That's when we get into that substantive constitutional issue. And many constitutional cases, you guys, they'll never make it past these early doors, right? And that's not a failure of justice, right? This is the constitutional structure at work. Now, judicial review, right? This gives the court the authority to interpret the Constitution and invalidate laws that conflict with it. And judicial review comes from Marbury versus Madison. It establishes that the Constitution is law and that the courts have the duty to say what the law is. But judicial review is reactive, not proactive. So courts do not roam the legal landscape looking for unconstitutional laws. They decide real disputes between real parties. And this is why Article 3 limits courts to cases and controversies. Courts do not issue advisory opinions or decide hypothetical disagreements, right? We talked about that last week when we were talking about justicability, judicial review, right? And this exists, right? This exists to preserve the separation of powers, and it prevents courts from becoming political actors. So, if there's no point, right? If there's no real dispute, then the case will stop here. It won't go on to the next door, right? Now, even if a court can hear a case, that does not mean that it can hear that specific case against every defendant, right? Or grant every remedy. Judicial review answers one question, right? Can courts interpret the Constitution? It doesn't answer who can be sued, what relief is available, whether federal courts may act against a sovereign, right? At this stage, we're not asking whether the government did something wrong. We're asking whether the court is allowed to do anything about it at all. And this is where the constitutional structure begins to control outcomes. Now, judicial review, remember that's Marbury versus Madison, that allows interpretation, but it doesn't address sustainability, right? Or remedies, right? Even with a case, right? Barriers like sovereign immunity, the 11th Amendment, right? That might block it. This is jurisdictional, right? That's what we're doing here in judicial review. We're focusing on who can be sued and what relief, right? States can't be sued for damages in federal court without consent. If you need to look that up, that case is Hands v. Louisiana, 1890, right? We're checking if the court can act, not if the government was wrong, right? So imagine this hypothetical, right? Plaintiff wins on the merit, but loses on immunity. No recovery, right? Makes sense. So remember, remedies enforce rights. No viable remedy, then there's no case. Now, before you analyze anything else, you have to identify who is acting, right? Who is acting? This is the single most important analytical habit in this course, all right? So constitutional analysis begins by identifying whether the challenged conduct is attributable to a government actor, because constitutional limits apply differently or not at all depending on who's acting, right? So the Constitution is not a general code of conduct, right? It limits government power. Different actors are constrained in different ways, and the Constitution does not apply uniformly to everyone. So anytime you see a hypothetical multiple choice question that begins with Congress passed, right? Or something that says a state enacted or a private company did, then you need to stop and you need to identify that actor, right? So actor identification is step one. If you misstep here, then you're going to give the wrong analysis, right? Because constitutional limits apply differently based on the actor, as the Constitution restrains government power, right? So when we see Congress pass, when we see state enacted, we know that those are likely going to be state actors. Whereas if we see a private company did, right, well, then that's likely no state action. Because remember, the federal government has enumerated powers, right? No police power. And the states have broad police power, right? Health and safety. But they must yield to federal supremacy, right? And what about private actors? Well, they're rarely bound absent some kind of state action, right? And remember, bar essays, they often hide actors. So when you're going through this step, you have to spot all the actors and identify those actors to be able to ensure that you are applying the correct doctrine. Now, we try to categorize, right, these different actors to determine their powers, their limits, their suability, right, and their remedies. And so we have these 5 possible actors, right? We've got our federal government actors, right? And these people, they have enumerated powers only, right? Commerce, taxing, right? And review power under Article 1 and 3. Then we've got our state government, right? This is our police power, unless it's preempted, right? And then we have our 11th Amendment immunity. Then we have our local government, right? Like states, right? State governments. Then we've got government officials, right? They're suable personally, right? Those damages can come out of their own pocket, or we can sue them officially, like in Ex parte Young. And we'll talk about that a little bit more. And then we have private actors, right? We have just the Karen on the street, right? And the Constitution is inapplicable to these private actors absent state action, right? And how do we identify state action? The public function test, right? So remember, You have to identify who your actors are. Now, the actors matter because states begin with broad police powers, but the federal government does not have those police powers. So states may legislate for health, safety, and welfare and morals unless they're prohibited, right? And the federal government has no general police power. It must point to an affirmative constitutional grant of authority. Private actors, they're generally not bound by the Constitution at all. Why? Because a Karen in the wild is a Karen in the wild, right? And so we have to find a state actor. We have to find government action, right? Because that's what the Constitution applies to, right? So we have to be careful not to miss a step and jump right into equal protection or free speech. We need to do our good analysis. We've got to go through our judicial review, right? We've got to go through our justicability steps. We've got to identify our actors. And then we ask what limits apply to that specific actor, right? So remember, the actors dictate the constraints, right? States have police power. If you want to read more, read the case of Jacobson versus Massachusetts, 1905. It's about vaccines, funny enough. Federal, right? Federal must cite grants. That's McCullough versus Maryland, 1819, with the necessary and proper clause. And then privates, right? Private actors, they're unbound. And you can read about that in the Rendell, Rendell, Rendell Baker versus Kohn, Kohn, from 1982 private school firing case. And that's a really good case to read and go through because that is a very common hypothetical type situation that you can see in bar essays, right? So remember, avoid jumping into the rights first, right? Always remember, actor first, right? Now, once we know that the actor is a state or a state agency, the next question is whether that state can even be sued. Right? Now, this is the doctrine that comes from the 11th Amendment, which limits federal judicial power over suits against one of the United States. And that's what it says, against one of the United States. And we call this doctrine sovereign immunity. Right? And sovereign immunity says that states are generally immune from private suits for money damages. You know that money. Remember we looked and we covered remedies, right? We talk about how money damages, generally states are immune from private suits for money damages. And the reason why is it protects the state. And it preserves federalism by preventing federal courts from bankrupting states through litigation. And the 11th Amendment, it bars federal suit against states by private parties, by foreigners for damages. It protects state treasuries. It protects dignity. That's the Hands v. Louisiana case. And at its core, right, states, agencies, state agencies, they're immune unless they have waived that. Why? Why would they be immune? Federalism, right? Because federalism prevents federal overreach. Now, this is one of the most misunderstood points in constitutional law, sovereign immunity, right? Because sovereign immunity does not mean that the state acted constitutionally, first off. It just means that the court may not be able to grant certain remedies, right? So the Constitution can be violated even when no damages are available. Now, if damages are barred and no other relief is available, well, then the claim ends here. That's it. Do not pass go, do not collect $200, right? Immunity blocks remedies, you guys, not validity. States can violate rights without liability. Jurisdictional, not substantive, right? And that's the Alden versus Maine case of 1999. Extending that to state courts. So if there is no remedy, right, like damages are barred, there's no injunction needed, then the claim ends. That's it. There's no more to do. So these are the important steps that we go through, right? Now on the screen right here, what we have up is a chart. And this chart tells you who can be sued and for what relief, right? It tells you whether a claim can move forward. Now, at this stage, courts stop asking what happened. They quit asking what happened, and they start focusing on who is the defendant, what relief is being requested. And this is where students realize that constitutional enforcement, that happens through remedies, not declarations. A case can fail even when the plaintiff is quote unquote right, if the remedy sought is unavailable. Right? So remember, anytime you see state agency or state department, start thinking sovereign immunity and remedy limits. Now, we talked about Ex parte Young a few minutes ago, and I said, don't worry, we're going to come back, right? Now, Ex parte Young exists to prevent states from insulating constitutional laws. Now, Ex parte Young is a Supreme Court case that was decided in 1908. And so this is the problem, right? Minnesota passed a law regulating railroad rates, right? And the railroad argued that the law violated the Constitution. Well, the state argued it could not be sued because it had sovereign immunity. Well, the issue was, if states can't be sued, then how's the Constitution enforced against them, right? I mean, it's a very good question. And so the holding in that case stated that when a state official enforces an unconstitutional law, that official is not acting as the state. And because they're not acting as the state, they may be sued for prospective injunctive relief. Now, without this doctrine, states could violate the Constitution with impunity, right? They could get away with doing whatever they wanted. The Ex parte Young doctrine states, right? This doctrine allows the courts to stop ongoing constitutional violations without awarding damages against the state. See, it's kind of like a workaround, right? And so it is essential to enforce supremacy without damages. Well, why? Why? Because we want to prevent impunity, right? So if you have any questions about how we can bring suit against an employee, right? And we can avoid the sovereign immunity of the 11th Amendment. What are we going to do? We're going to look at the Ex parte Young case from 1908, where there was a railroad, right? And the issue in that case was, if states can't be sued, how do we enforce any of this, right? Well, that's the case, it says, right? When a state official enforces an unconstitutional law, that official is not acting as the state, and they may be sued for prospective injunctive relief. Está muy importante. Comes up a lot in essays. Now, let's talk about the limits on Ex parte Young, because this isn't a loophole, right? Using Ex parte Young does not provide you a loophole for damages, right? Ex parte Young has very strict limits. Now, the relief must be prospective. It must be prospective relief, meaning no retroactive, no going back in time, right? No going back in time, only moving forward. So the relief must be moving forward. The violation has to be ongoing, right? If it's not, right, then what are we here for, right? Claims that are based on the past, right, they don't get to move forward under Ex parte Young because there's no ongoing violation to enjoin them, to stop them from doing, right? And there's no retroactive money relief. If the plaintiff seeks retroactive money relief, then Ex parte Young does not apply. Now, if relief looks like damages in disguise, you guys, that should be a big red flag, right? I hope sirens go off in your head, wah, 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 because the case is barred, right? Because remember, we've got these limits on prospective, ongoing, right? It has to be prospective, ongoing violations. No retroactive money, right? No asking for retroactive relief. The name of that case is Edelman, right? Where back wherefore payments were barred. And remember, there's no disguised damages here, right? Restitution. So you want to stop your analysis if the relief is starting to look backwards, if it's starting to look like your standard damages analysis. Now, if a business sues a state agency for damages, what happens? The case ends. The case ends if a business sues a state agency for damages. The conduct does not matter if the remedy is barred, right? So if the same business sues the agency head to stop enforcement, Now the case can proceed. But if they sue for damages, that's it. The case ends. Nothing about the underlying conduct changed. Only the defendant and the remedy have changed, right? So remember, the Constitution is enforced through these procedural pathways, not moral conclusions, right? Businesses sue states for damages. What is that? That's barred. Barred. Same, right? The same business sues an official for an injunction. Ah, that one proceeds. That's ex parte Young. Yay, right? So remember, procedure trumps substance. We want to go through the steps in constitutional law very, very methodically at a top down manner, step by step, right? And so that we can ensure that we're not missing out on the procedure, right? Because procedure trumps substance here. Now, even when the defendant can be sued, the Constitution still may not apply. Remember, we said that earlier. So the Constitution regulates that government behavior, not private choices, right? Not private people. You can't just be like Mr. Smith in Iowa, right? No, it applies, right, to the government, not private actors. So without this doctrine, every private dispute would become a constitutional case. Can you imagine your neighbors call because you're playing your radio at 2 a.m. and you're disturbing the neighbors, and your neighbor calls because you're violating the Constitution? Like, be crazy, right? And so we have to remember that this is a separate gate, even after jurisdiction and immunity. So the Constitution limits government, not private people, right? So separate gate after jurisdiction and immunity, right? It's a separate gate. Why? Because it's going to prevent flooding the courts with private disputes. No state action, no claim, right? No claim. So private conduct, you guys, is treated as a state action when the government is truly responsible for it. So there are times, don't let them fool you, when just an average Joe, right, a private actor might be treated as a state actor, right, where the government is truly responsible for it. And this occurs in limited situations, right? And we've got public function, right? So if it's a public function and that individual is doing it, then that is treated as government action, state action, where the government has coerced or encouraged you to do something, right? So imagine if there's a neighborhood and the local police department said, we're going to train the, neighborhood watch groups, and we're going to give them badges, and, they're encouraging them, right? This is a state actor encouraging private people, right? And so if they're encouraging these private people, right, and they're doing like a kind of a police function, right? Because I mean, walking around your neighborhood with walkie-talkies, reporting it like the police, now they are private actors, right, that are performing state action, right? Because they're doing what the cops do, which is traditionally and exclusively a government action, right? In that situation, we would be able to say at that point, although they are private actors, they are performing a public function. You could even argue, right? Because remember, we have two tests here, that private conduct became state action because they entangled themselves with the police department, right? The police department encouraged them. The government significantly encouraged or facilitated the private action. What did they do? They bought them radios, they gave them training. And what happened? The government became entwined in there, right? They became so entwined that private entity's operations are functioning as one with the government now, right? Because they're using government radios, they're reporting it into the government, right? And so now that private, neighborhood watch group has now stepped into state action territory. Ooh, right? And so we want to look for private persons, private actors, and we want to look for those people enforcing government mandates or being deeply entwined with entities, right? And so remember, it is state action if the government is responsible. But we have the public function test, the coercion encouragement test, and the significant involvement slash entwinement. And with that public function, what we're saying is that this is a traditional exclusive, state role that has traditionally been done by the state. And that would be the Marsh versus Alabama case from 1946, right? And the public function test does not apply to dispute resolution, although that's not very much tested. The coercion encouragement test, right? That can be seen in the Shelley versus Kramer case from 1948. And that court enforced the covenant in that case. And that was a state facility to discrimination case. And then with that significant involvement, that entwinement, right? You have to have these deep ties. And so this is a great place to start reading some of these more interesting constitutional questions in the Brentwood Academy versus Tennessee Secondary School Athletic Association of 2001, right? Where they identified public officials were dominating a private group, right? It's very interesting how they were like, well, this is an entwinement. So you should go take a look at those cases and see how they go through those to determine when private conduct becomes a state action. Now, remember, regulation alone is not enough, right? And courts have repeatedly held that certain government connections to private actors do not, standing alone, make that private conduct into a state action, right? So the government must be responsible for the conduct. If there is no state action, right, then the constitutional claim ends here. If it's a mere regulation, meaning if government regulation of an industry or activity, even if it's really intense, that does not make regulated private entities state actors, right? So think about these coal manufacturing or coal power plants, right? There's quite a lot of government regulation on top of the coal industry, but that regulation alone does not make that coal plant a government actor, right? And then licensing, right? Because oftentimes, we require private actors to get government licenses or permits, right? We need you to go get a concealed carry permit. Obtaining that concealed carry permit does not turn you into a state actor. Just because you have a license does not make you a state actor. Government funding, right? Receiving government funds, right? Contracts or money does not automatically make you a state actor. So let's say that, you're a daycare and you receive money from the state, right? You're subsidized by the state. That does not mean you, the daycare owner, is now acting for the state. So be wary, because these are the little tiny things that distinguish these. And these, we oftentimes think that we're going to spend most of our time in constitutional law arguing over whether or not was that free speech, or is that the right to bear arms, or when in reality, what we're doing is we're really taking a look at, little tiny procedural things, and we're arguing over things long before we get to the constitutional analysis. We're arguing over whether or not whatever this person was doing, were those acts sufficient enough to be constituted as a state actor, right? And so there's a lot of discussion and a lot of, back and forth that's going to occur in constitutional law analysis, even before you get to substantive constitutional issues. Now, let's get into the state action example, right? And we've got a hypothetical here. So a private hospital receives Medicare and Medicaid reimbursements, right? And they have to comply with federal and state health regulations. Now, the hospital denies treatment to a patient, right? Citing compliance with the state regulation governing emergency room triage protocols. And the patient sues, claiming that the hospital violated constitutional due process rights. All right, so how are we going to go through this analysis, right? Well, we want to look at that government involvement, right? Because we're looking at the state actor. So the hospital receives government funds and they have to comply with this extensive regulation, but we saw that regulation, being regulated, having a license, or having, having to go and get a bar or whatever, that is not enough to show government action, right? And so the hospital is going to cite state regulation as the reason for its decision, right? And neither the funding nor regulation here in this situation is sufficient to identify the hospital as a state actor. There's no evidence that the state coerced or encouraged the specific denial, right? And a private hospital following regulation, they are still a private actor. So without coercion or encouragement, the Constitution doesn't apply, even if the results feel unfair. Now, a private hospital denies care under regulations. There's no state action absent some kind of coercion. That's the Blum case, right? Now, if the state mandates this, then maybe it would be a yes, but we would have to see what that says, right? So remember, focus on the responsibility for the act. Focus on who is responsible for the act, right? So remember, a funded school and they discriminate against somebody, is that state action? It's not state action, right? If it's an independent decision. Remember, we said in the state hospital example, if the state required it, if the state mandated they take that action, then yes, we might have a good argument to say that that was state action. But in this situation, the mere fact that they were regulated and overseen does not make it enough to be found a state actor. Now, at this point, courts have asked 5 questions, right? Now, is there a justicable case or controversy, right? Is there a justicable? This is justicability, right? Does this dispute present an actual case or controversy under Article 3, or is it advisory, moot, or unripe? This was the first session we went through, right? What we went through today was who's the actor, right? Is the challenge action taken by Congress? Was it done by the president? Was it done by a federal court, by a state court, by a district court, by a local government, or a private actor? And then we touched on, is the defendant immune from suit, right? If suing a state or a state agency, right, we learned when the 11th Amendment and sovereign immunity shows up to bar this claim against this defendant, right? We touched on, is the remedy available? Can the plaintiff obtain the relief requested? The damages versus an injunction from the defendant given the immunity doctrine. Remember, we talked about that immunity, right? We went in, I think it's around the 11th Amendment slide, where we were talking about you cannot get money, no dollar bills, right, out of the government. You can only get relief. You can only request injunctive relief, and it can be prospective relief, not past, right? And then, is there state action, right? If it's a private actor, is there sufficient government involvement, government entanglement, coercion to satisfy the state action requirement? And the failure of any of these things to be met, that stops the constitutional inquiry, right? That stops the constitutional inquiry. If the answer to any of these questions is no, that's it, you're done. Now, these thresholds matter because what they're going to do is they're going to filter out many of the claims, right? They're going to prevent premature rights analysis. They're going to ensure that you walk through the steps before you jump into that substantive constitutional analysis. And they're going to shape how the cases are argued. Because in these first steps, as you begin your analysis, if you do not correctly identify state actors, then you call somebody a private actor, that's going to change your entire analysis. That is going to affect how you are going to argue the entire case that is in front of you. And so as you're going through constitutional law, remember these concepts are going to reoccur. Right? We're going to learn them now, but these concepts, such as commingling and coercion and state actors, right? They're going to reoccur constantly, right? They form the gateway through which every constitutional claim must pass. They do. So remember, don't skip these steps, right? Don't overanalyze your rights. Don't miss dispositive issues because you'll lose points, even if you know the doctrine, if you do not use a strong constitutional analysis, right? If you do not go step by step through this justicability requirement. And so with that, you guys, that is it. In the next class, we will be finishing up in our session. And then after that, I believe we'll be moving into those substantive rights. So remember, if you guys have any questions, feel free to reach out anytime. And I look forward to talking with you guys later. Have a wonderful afternoon.